Murder charges against Cara Rintala. This is Rintala's fourth trial for the 2010 death of her wife, Anna Marie Cochrane Rintala. Her previous trials ended with 2 hung juries in 2016, and in her third trial, Rintala was found guilty, but that was later overturned by a higher court ruling in 2021. Now, back on the night in question, when the authorities arrived at their home, Rintala was found covered in paint, cradling her wife's body in the couple's shared basement. Anna Marie was also covered in paint and showed signs of manual strangulation, among other physical abuse. Now, as we await a verdict, let's listen back to some of the Commonwealth's closing argument, and then we'll chat on the other side.
She makes a small purchase of groceries inside Stop and Shop. Interestingly, no pretzels. Supposedly the whole reason she detoured from the Big Y to Chicopee. Nope, let's go to Stop and Shop. Got to get those pretzels. Doesn't even buy the pretzels. Leaves another voice message, another text message for Ann. Then it's off to Burger King for the mac and cheese, which she purchases at 6:48 p.m. 6:48 p.m., she purchases the mac and cheese. She leaves another voice message for Ann 10 minutes later. Now this is interesting because 10 minutes later, she's home. Burger King to 18 Barton Street, 8 to 10 minute drive. She's practically home, if not in the driveway, when she leaves that final voice message for Ann. The voice message in which she says, "Call me." Bless you. Why does Ann need to call her? Bless you. She then leaves everything in her truck. She doesn't bring in her purse, her cell phone, the groceries. This is according to the defendant in her interview and based upon the evidence at the scene. She looks down the basement stairs. She sees her wife. And what does she do? Rather than rushing down those stairs, not only, let's put aside for a second the fact that you're a trained paramedic, okay? Maybe your training goes out the window at that point, but this is your wife lying on the floor, unconscious, possibly injured, in need of medical help. Time is of the essence. Yet, she gathers up the baby, goes to the neighbor, asks the neighbor to call 911, goes back to the house, then goes back into the basement, rolls her body, her wife's cold, stiff body up onto her legs, is smearing paint over her body, and is angry when the police arrive. That makes no sense because that is not what actually happened. The defendant did not come home to discover her wife dead. She came home to discover her wife still dead in the basement. And in one final act of concealment, one last-ditch effort to complicate this crime scene, she pours the paint. Paint that was consistently described by the first responders as wet, liquidy, shiny, from which you can infer, using your own everyday life experience and common sense, that that paint had been freshly poured. And ultimately, that created a big problem for the defendant because now you had two vastly different timelines at this crime scene. You had a cold, stiff body versus fresh, wet paint, and those don't match up. All 3 forensic pathologists who testified in this case agreed that Anna Marie's body was in well-developed, if not full rigor mortis, when first responders first saw her that evening. Dr. Richmond testified that she'd been dead for 6 to 8 hours or more. Dr. Andrew testified that in his opinion she was dead by 1 o'clock. Dr. Littman agreed that the average for well-developed to full rigor mortis is 6 to 8 hours. Now, not all opinions are created equally. Dr. Richmond and Dr. Andrew formed their own independent opinions without needing to know what any other doctors had to say on this topic. Dr. Richmond and Dr. Andrew were not asked to place Ann's time of death either on one side of that 3 o'clock line or the other side of that 3 o'clock line. the line that Dr. Lippman knew about from square one, in which she knew was a critical dividing line in this case. This information that's coming into her head, which she doesn't need to know, is consciously or not affecting and skewing her opinion in this case. Dr. Richmond and Dr. Andrew correctly and appropriately took into account the drastic, stark drop-off in Ann's cell phone activity on the day that she died. The type of evidence that all three doctors agreed is important and critical to factor in to help estimate and narrow down one's time of death. Dr. Richmond and Dr. Andrew correctly took into account the fact that Ann was lying on a cold or cool cement basement floor, which would slow down rigor mortis, particularly when wearing little clothing on top. And regardless of whatever some dehumidifier may have said in some area of the basement, as far as where the temperature may have been in that section of the room, regardless of the air temperature in the basement at all, as Attorney Scapiccio apparently agreed a short time ago, that basement floor would be cold or cool in March in New England, sucking heat out of Ann's body. And Dr. Richmond and Dr. Andrew agreed that there was no evidence, absolutely no data, to support the notion that Ann had been involved in some prolonged, physical, vigorous, violent exercise or struggle. Absolutely no evidence. They didn't make assumptions. They didn't speculate. They looked for what the data was, and there was none. Now, ultimately, Dr. Lippman had no opinion as to when Ann died. She acknowledged that Ann could have died before 3 p.m., consistent with that 6 to 8 hour range, that average. And remember what two factors she cited for supposedly sliding that average down to maybe 5 to 7, maybe 4 to 6. She couldn't say how far it would slide down. She cited two key factors. One was this alleged violent struggle. She admitted on cross-examination. I asked her, now, doctor, would you agree that there's no evidence, there's no data regarding the duration of any struggle in this case? And she said, yes, I agree. I then asked her, what evidence or data is there that Ann was actively engaged in this struggle as opposed to being on the receiving end, a passive recipient of this assault? She agreed, there's no evidence, there's no data for that. She agreed that not all struggles necessarily speed up rigor mortis. And despite acknowledging that Ann could have been dazed, could have been in tremendous pain, could have been unconscious as a result of the significant head wounds that she sustained, she still held on to this assertion that there must have been a struggle.
All right, with me, I still have trial attorney Krista Ramey, and I now have trial attorney Catherine Lizardo. Catherine, I'm going to start with you. This is the fourth trial. Is for the magic number. That was the summation you heard from the prosecutor. I actually thought he did a very good job. What are your thoughts?
I thought so far that I've heard he's doing a very good job. He was doing a very good job, especially when he mentioned about the paint. The paint issue here in this trial and this case in general has been very critical, because the reason the third trial, the guilty verdict there, was overturned was because of the paint expert. On appeal, the Court of Appeals ruled that the paint expert should not have been allowed to testify the way they testified. That's why now we're having the fourth trial. And here they didn't have to use the paint expert to find out the timing of her death. Instead, as we heard in closing, that they're using the common sense of the jury to analyze that the paint was cold, wet, and freshly poured on both of their bodies, not just Anne-Marie, but both of them, when the first responders came. So I think that was very important to point out.
I agree. Krista, do you agree? I mean, do you think we're going to have, first of all, a conviction? I mean, the verdict hasn't come in yet. We're waiting to see what that jury is going to do. But the prosecution probably learned quite a bit from having tried this case now for the fourth time.
Well, I have a big problem with 4 trials in one case. I think that, if this prosecutor does not get a guilty verdict, that there should be serious questions about the ethics behind bringing someone to trial 4 times. After 2 hung jurors, it probably should have stopped there. We're at 13 hours now, 13 and a half hours, almost 14 hours into deliberation, which does not bear good for this prosecutor. So while I heard some pretty cogent arguments there and what we just listened to, when you're putting this whole case together, I don't know that this prosecutor brought it over the finish line. You should have seen a much quicker verdict if that was the case. So you've got some holdouts here, and I think you're probably looking at another hung jury.
Yeah, I mean, I think you're right. Catherine, do you think, what are they, I think, debating back behind those closed doors? Are they talking about the paint? Do they think that she was riding around trying to have some sort of alibi? I mean, they're clearly not all of one mind at this point.
Yes, and it's been 13 hours, as what Krista mentioned. And there are a lot of issues that they have to think about here. The murder, or Anne-Marie, died in 2010. There has been a lot of witness testimony, and memories have faded, even though the trial has been going on, and this is the 4th trial now. So there's a lot of differences still from the previous 3 trials. And I think the jury are taking their time to make sure they get it right. And for the prosecution, I think it's good for them in a way that the jury is taking their time, because like Krista mentioned, this is the 4th trial and they have to get it right this time.
They absolutely have to get it right this time. We're going to take a quick break, but when we get back, we're going to listen to the defense closing argument. So stay with us.